A lot of people are freaking out right now about filing their N-400 application for naturalization. And I can't tell you how many people I've recently consulted with who failed to disclose minor things on their green card application, the I-485, and now they're really worried about filing the N-400 application. The question that I was presented with, and which I initially didn't really know the answer to until I did some legal research, was should I keep the I-485 application consistent with the N-400? For example, if you had a minor traffic violation, like a speeding ticket, and your lawyer told you, you don't need to really disclose that on the I-485 on the green card application, and then you got your green card and all was good in the world. And now it's time for naturalization. And they ask you, have you ever been cited, arrested, detained, and like 50 other things? And the answer is, the honest answer is yes. So in that situation, what do? Do you keep your N-400 consistent with the I-485 application? Or do you now disclose something new that you should have disclosed on the I-485 application and take any risks that might come with that decision? I was really initially conflicted about what to do because in the past there has been guidance that, minor traffic violations don't need to be disclosed on the N-400. And in the past, there was also guidance suggesting that they might not need to be disclosed on the I-485. Additionally, it's further complicated by the fact that some minor violations or even minor crimes that are non-traffic in nature, like disorderly conduct or something pretty low level that might be a violation in some jurisdictions, might be a low level misdemeanor in other jurisdictions. These are not considered to be material crimes, which means failing to disclose it would not be considered to be a material misrepresentation. It wouldn't be enough to get your green card denied. So many lawyers would advise people that you don't need to worry about it. You don't need to disclose it. So what I did was, I'm in a group of immigration lawyers and I posted this question for the group. And I actually created a poll for people to answer. And I printed out the results here, and I'm gonna keep the identifying information confidential, but I'll just tell you generally. So the question I posed for the group is, if somebody failed to disclose a minor traffic violation on their I-485 because their lawyer told them it doesn't need to be disclosed, would you now disclose it on the N-400? And then I gave a few options for them to answer in the poll. First option is disclose it on the N-400, knowing that the N-400 can be denied because of the inconsistency. That was my option that I posted. Or keep the I-485 and N-400 consistent, or not file the N-400 at all. So keep the I-485 and N-400 consistent only got 1% of the total vote. Not file the N-400 at all got 4% of the total vote. And disclose it on the N-400 knowing that the N-400 can be denied because of the inconsistency got 95% of the vote. And some people provided their own answer saying disclose it on the N-400, mark an asterisk, and explain in the additional information page or do a separate addendum. And then someone else said just file the N-400 and disclose it, no need to explain at all. And that's pretty much the variation of what everyone said. A few of the comments that people posted are notable and I'd like to share them with you. These are all reputable immigration attorneys who I have the deepest respect for. So it's not just random people. A simple traffic violation isn't material for green card purposes, but if not disclosed when filing the N-400, it can be denied for misrepresentation. And that this was a common theme. There were 40 comments on this thread, and that's the common theme throughout from all the attorneys who've recently had issues like this. Someone said, I recently had someone come to me for an N-400 denial because they failed to list a red light camera violation and a small civil traffic infraction. And just for that, the N-400 got denied. Someone else posted, I've run into these situations before. The minor traffic violations would not have been material to the I-485 application unless it was criminal in nature. But you still have to disclose it in the N-400. because that is what it is asking. Some attorneys mistakenly believe that the question doesn't really refer to traffic citations, but that is an incorrect reading, and that lawyer misadvised. They're referring to the lawyer in the post, my initial post. So the lack of disclosure wasn't the client's fault. I have disclosed traffic citations even if past attorneys did not, and it has not been an issue, especially if it was outside of the 5-year statutory period. What they mean is the 5-year good moral character period, because you need to have 5 years of good character before you submit the N-400 application in most cases. I also add a clause that the citations are being disclosed to the best of their knowledge and recollection, and that as far as they know, nothing is outstanding, because many people forget some minor traffic tickets. I don't think you need an affidavit. Just prepare the client to address it if the adjudicator makes it an issue. The overwhelming consensus is disclose it, even if it wasn't disclosed on the prior I-485. And then there's some disagreement about whether you should attach an affidavit explaining it, provide additional information in the space that allows you to provide additional information. My takeaway from all of this was that we will disclose it for all of the N-400 applications, and we will not provide any additional information, but we will prep with the client so that they can answer questions about it in case the adjudicator, the immigration officer, makes it an issue during the interview. If you have a situation like this, it is a good idea to speak with an immigration attorney before you file the N-400 by yourself, if you plan to file it by yourself. If you want to speak with me specifically about your immigration issue, you could always schedule a consultation. The information for consultations is in the video description below. We can go through your specific issue because some crimes can have serious immigration consequences. If it was, for example, something that would deemed to be a crime involving moral turpitude and you failed to disclose it before your I-485 was approved, that would be a huge issue. Your N-400 could be denied because you are not properly a permanent resident, and the N-400 denial would say you are not properly admitted for permanent residence. That's one of the requirements for naturalization, and so we're denying this. In that situation, it's unclear whether the case would result in a notice to appear in immigration court to begin deportation proceedings. So far over the last few years, that's not what I've seen happen. Usually it just ends with a denial decision and most people can keep their green cards. It's unclear right now whether that's going to be the policy moving forward. I haven't had direct experience with any of these exact crimes involving moral turpitude resulting in the N-400 application getting denied. If we get any updated guidance on this, or I encounter any situation, whether another lawyer posts about it or I experience it myself with one of my clients, I will definitely make a video sharing it with you guys. If you're interested in learning more about these topics, be sure to subscribe to my channel, and I'll see you guys next time for another video.